So, it has to be a sitting in the Legislative Assembly, not outside, while the resolution is under consideration. So it gives you the time, the point in time.
Your point.
Yes. Yes. Not at the time when leave is granted, not any time earlier. That's the only embargo. So because the Constitution gives you the point in time that he cannot preside. Now this relates to him. There is no conflict of interest between him and third members under the 10th schedule. There is no conflict of interest. So you can't apply the principle of conflict of interest to a proceeding under the 10th schedule where he is dealing with third parties. So the whole premise of the argument is untenable.
There are 2 points here.
Yes.
That is, while is one aspect, and the other is that this talks only about himself. And
That's all my contention is. You can't make a constitutional assumption, mother, because the whole argument has been on the premise that there is a constitutional assumption that he'll act mana fide. When Kyoto Holohan, just that paragraph of Kyoto, mother, I'll give to your lordships, says you can't attribute to the speaker any such mana fide. That's why the provision of the 10th schedule was upheld. And just give your lordship just the page. I marked it on the, just that paragraph I'll give to your lord.
You so easily vacillate from reposing such great confidence on the speaker on the one hand. Within a split second, you would again, you means, I'm saying,
I agree.
in a split second, we know how the speakers have worked.
That's true. But that is why.
These two things which go from.
That is why the minority, according to me, was right. Because only you had to only strike down that part which gives speaker the authority. The rest of the 10th schedule would be maintained. The problem is with the speaker. Yes.
A noble judge, a noble chief justice is making a noble assumption about
yes.
That's not how things have panned out.
Those are different times.
But the point is, you as a constitutional court cannot on the assumption proceed that he will act mana fide. That's the point. That's why your lordship keep on asking me what if he does this and what if he does that. That constitutional assumption you can't make. Otherwise, he should not be the authority which adjudicates.
Can we overlook the situations that have been thrown up after 92?
No, I'm not saying overlook it, Mullah. I'm the last one to say overlook it, Mullah. In fact, I'm the one to say he should not have that authority. But I'm saying as the law stands, so just note that I will not read it. 115, 118 and 119. In 119 it says, accordingly the contention that vesting of adjudicated functions in the speaker would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected. Anyway, I'm deeply obliged to it. Your lordship will pardon me. Yes, sir. Yes, deeply obliged. And I'm grateful to your lordships for the time you have given.
Thank you, Mr. Sibal.
I'll just in point form a few points. Let us get back to the discipline of the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my lord put between. I think my lord the Chief Justice put it. In fact, Justice Shah and Justice Narasimha also put it. Was Nabam Rebia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethmalani tried to address that issue directly to them. And perhaps he has not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your lordships. Just note in sequence, the lordship will be astonished how much entirely relies on Nabam Rebia, which is why your lordship will refer it, unless your lordship wholesale agrees with Nabam Rebia, obviously. If your lordship doesn't agree with Nabam Rebia, it has to be referred. Now, let's kindly note that. Just note the pages first to save time, then I'll show the pages. My learned friend, with great respect, has made an oral argument without being advised about his own client's pleadings, or at least his related client's pleadings. PDF 160, I'll give all the PDF first together, so lordship will be able to follow it more easily. PDF 160, this is all in compilation CC1. That is not case law compilation, but the main CC1.
CC1.
Pleadings.
Convenience compilation.
Yes, CC, convenience compilation. The PDF pages Siriati Mar 160, 167, 174 and 193. 4 pages.
193.
Yes. So 160, 167, 170, 193.
174 or
174 you said.
Yes, I'm very sorry.
174 and 193.
That's right. So 160, 167, 174 and 193. And one more thing is, they then have filed written submissions here opposing the reference in your Lordship's court. In that written submission, page 3, para 3, there are 5 things. Now, remember, your Lordship is considering only 2 issues. A, are you agreeing with Navam Rebia or not? That your Lordship has already heard in the merits first. These are the errors of Navam Rebia, they are the problems, they are the consequences. The other is, Navam Rebia is only a casual, marginal, possibly inconsequential basis of the other side's case. In which case, even if your Lordship disagrees, why should your Lordship refer it? Number is, this is completely, I'm astonished. Now turn to Willis, 160. This is how we came on 24th, 25th, 27th, etc. of June.
What is this page 160 that you are reading out?
I am reading Willis, 160.
What document?
The actual petition.
Sorry?
Part of the writ petition.
It's the writ petition
All
by
right.
which the whole thing was born. Whole thing started, and this is what we argued.
It petition filed by them. On which 27th order was passed.
On which, and that's the foundation, the main Shinde petition, if your Lordship may so call it, on which everything is founded. That's Willis 160, I'm sorry. It's a short paragraph. 34 MLAs of Shiv Sena issued notice, including few independent MLAs, issued notice under Rule 11 of the Maharashtra Assembly, read with Article 179 of the Constitution to the Deputy Speaker, Mr. Zirwal, to move the motion for removal from the office of Deputy Speaker and requested him to refrain from discharging the functions from immediate effect. A true copy of the translated notice of 21 June, etc. for his removal is annexed. Now there is one important point here. I did not say it until I showed the page. Along with this reliance on Rebia, which I will develop in a minute, is a major suppression. Major suppression. And both suppressio veri and seditio falsi, both aspects also. Your Lordship heard hardly 1 hour ago that nothing turns on this because this was rejected. Your Lordship heard it just now. Where is the rejection mentioned here? You have come to a court in a vacation seeking urgent interim relief involving the possible toppling of a government. Today, because it suits you, you argue that it was rejected. Now the whole para is here. Lordship will look behind and forward. There is no mention of rejection. It's completely suppressed. Now go on. Kindly proceed further. Now come to 174. So there is a remarkable intersection of suppressio veri, seditio falsi, and reliance on Rebia. It will just, when I complete it, you will see the total picture. And it's true in constitutional adjudication, we can have very large, nice issues, but ultimately there should be some discipline of law. How you came to the court, what you relied on, today your Lordship is considering reference, not the merits. 174. Oh, sorry, 167. My apologies. I gave the wrong page.
That specifically refers to Navam Rebia.
Yes. Now comes the ground, the first ground. No, see the whole construct, the basis on which you came, you entered the door with this basis, got an order, and today because Navam doesn't suit you, you have been disloyal to Navam and dethroning it. The petitioner is filing the present writ petition on the following amongst other grounds which are taken in the alternative. First ground. First, Deputy Speaker cannot disqualify any member under Schedule 10 during the pendency of his own removal resolution because this Honorable Court in Navam, so-and-so, has held that the Speaker or the Deputy Speaker during the time of the pendency of a notice of resolution for removal cannot disqualify any member. The relevant paragraph reads as follows. Now we have harassed your Lordships enough time in this paragraph, but look at the length of the quotation. This is the writ petition's first ground. This ends at 173 after 3 pages, entirely same paras we have read above. Paras are the same, but no disclosure of rejection. The title is when a resolution for removal of his own removal is pending. Mark the word pending. The next sentence should be, oh, but yesterday it was rejected. Your Lordship should know that. The word pending is used, own removal is used. This is a suppression of the worst kind. Now, it's not just, I remember, I'll give you a citation. There is 1976 judgment of the Lordships. Take out that. Which cite 64, just a digression for a minute, Lordship will see what standard the Lordship is to maintain. And it's all right, your Lordship is crowded today, so your Lordships always can't maintain it. 76 Supreme Court, cite 64. In 64, Mr. Settlewatt appeared. I'll give those two citations to your Lordships. And it was found that one of the grounds in the SLP was false or wrong. Misstatement. So Mr. Settlewatt appeared the second time and the judges agreed with him and he said, I never argued this ground. It is a misstatement. I never argued the ground. And he says, we will take your statement, Mr. Settlewatt, as correct. We did not grant leave on the basis of this because you never argued this ground. But we will revoke leave because there is a misstatement. Now this misstatement is the basis of getting whatever order you got on 27th.
On 27, according to them, there was no injunction.
No, but it's kindly, now, kindly see, on 25th or 26th or 27th, would the speaker have disqualified or upheld and said no disqualified? Just, can you go step by? This is very important. This is the biggest fiction being propounded to your Lordships. Suppose there was no order by the vacation bench of this court. Just for a minute, efface the slate clean. The speaker would be at liberty on that day, which is the 27th, to either disqualify XYZ or not disqualify. The speaker had given them time till 25th, so his hands are free till 27, 2 days. Your Lordship does it frequently, as I appeared for 2 hours, matter went until 9 o'clock in the night. The learned judge said that the effect is the same, we extend the time and we'll be hearing the matter. When your Lordship extends the time to file a reply, can the speaker decide? Stays or interim intervention by a Lordship says many forms and models. They come in myriad colors.